In the previous session, we clearly understood what a contract of sale is, the difference between sale and agreement to sell, and how property and risk pass from the seller to the buyer. Now, once ownership is transferred, real life problems begin to surface. What if the goods are defective? And what if the seller cheats? What if the buyer refuses to pay? Or what if the goods are lying in the godown and nobody is taking the delivery? Now, this is where Sale of Goods Act steps in, not as a mere law but as a protector of fairness in business transactions. Okay, now let us start today's session with a powerful principle that governs the contract of sale. That is caveat emptor. Now let the buyer behave. Now that is the actual translation of the word caveat emptor. This means the buyer must take the responsibility for checking the quality, suitability, and fitness of goods before purchasing. The seller is not bound to tell every defect unless the law or contracts requires him to do so. So the core idea is when you go to a shop and buy something, the law assumes you examined the goods, you chose them, and you accepted the risk. So if later you realize the product is not suitable for your purpose, the seller is generally not liable. For example, Ria buys a laptop for designing work without telling the shopkeeper her specific purpose. Later, she realizes the laptop cannot run design software properly. Now, the seller is not responsible because Ria never communicated her purpose. So, having said that the buyer must beware, I will also tell you some of the cases where the buyer is protected, which means I will now be discussing exceptions to caveat emptor. Okay, so let me walk you through some of the cases where the buyer will be protected. Now, if the buyer clearly tells the seller the purpose and relies on the seller's skill, the goods must be fit for that purpose. For example, if Aman tells a shopkeeper, I need shoes suitable for mountain trekking, the shopkeeper gives normal sport shoes, the seller will be held liable. Now, this is what is known as fitness for buyer's purpose. And then, what if goods are sold by description? Now, if the goods are sold by description, they must match the description. For example, you order pure silk saree online and it turns out to be some artificial silk. Now, here the buyer is protected and the seller will be held liable. Then, goods, if the goods are sold based on sample, in such a case, the goods must match the sample that is shown. Now, for example, a sample of rice is shown as a long grain premium rice, but delivery contains mixed quality rice. Now, here also the seller will be held liable and the buyer will be protected, which means this is again an exception to the principle of caveat emptor. And next, if the goods are sold by description from a seller who deals in such goods must be of merchantable quality. So, for example, buying packed biscuits that are expired, even if you don't check the expiry, the seller is liable to actually sell you the goods which are within the expiry period. So, in case he sells you those expired products, then the seller will be held liable. Okay, and then implied conditions based on trade practices apply. For example, buying cement from a dealer, it must be usable for construction as per market standards. Okay, and if at all a seller hides defects knowingly, now caveat emptor does not apply. So let's say A sells a car and where he has painted on the rusted part to hide the damage. Now, here A clearly knew that there are some defects in the car, but still he sold it to you, which means he had the intention of deceiving you. So, here again the principle of caveat emptor will not hold good. That means the buyer will be protected here and the seller will be liable. So, this was about the concept of caveat emptor and also some of its exceptions. Now, let's move further to understand the buyer's rights against the seller in case of breach of contract of sale. So, the Act gives the buyer some strong remedies, and let's now understand those legal remedies which are available to the buyer against the seller one after the other. So, firstly, there is suit for non delivery. So, if the seller refuses or fails to deliver the goods, buyer can sue for damages. For example, you pay for a refrigerator, but the seller refuses to deliver. So, here the buyer has a legal remedy to claim for compensation. Okay. The next remedy is suit for specific performance. Now, if at all the goods ordered were unique or special, the buyer can always demand for actual delivery. Now, this is what is known as suit for specific performance. For example, buying a rare antique painting, money cannot replace it. So, therefore, the court may order delivery of the same item. Okay. Now, the next legal remedy is suit for breach of warranty. Now, if a condition in the contract of sale is breached and the buyer accepts the goods, he can claim damages. For example, you accept a mobile phone that does not have promised battery backup. Now, here you can claim for compensation. Okay. The next legal remedy available is suit for anticipatory breach. Now, what does this mean? If the seller declares in advance that he will not perform the contract, now, for example, seller says, I will not deliver the goods next month. Now, here, what remedy is available? The buyer can actually sue the seller immediately. Okay. Now, this buyer also has a legal remedy, that is suit for interest. Now, what does this mean? The buyer can claim interest on refund of price in case of breach. Okay, so these were some of the legal remedies that is available for this buyer against the seller in case of breach of contract. Now, let's flip the lens. Till now, we protected the buyer. But what if the buyer does not pay? Now, let me introduce you to a powerful character called unpaid seller. So, a seller is said to be unpaid when the whole price has not been paid or a conditional payment like check, etc., is dishonored. For example, seller delivers the goods, but the buyer gives a check, but the check bounces. Now the seller becomes an unpaid seller in this case. Now let's understand the rights of the unpaid seller against the goods. Okay. Now this is where the law gives the seller direct control over the goods. Now firstly, this unpaid seller has right of lien. If the seller is still in possession of goods and the price is unpaid, he can retain the goods. For example, seller has packed the goods in the warehouse and buyer hasn't paid. Now the seller can refuse delivery. Okay. Now he also has the right of stoppage in transit. Now, what does this mean? If goods are with the carrier and the buyer becomes insolvent, the seller can stop the goods midway. For example, goods sent by truck and buyer becomes bankrupt before delivery. Now, here the seller can stop delivery, and this is what is called as right of stoppage in transit. Okay, then he also has a right of resale. That is, a seller can resell the goods if the goods are perishable or if the buyer defaults after notice. For example, seller sells fruits to buyer A. Now, buyer does not pay. The seller has all the rights to resell to buyer B. So this is a valid resale. Okay. Now let's understand the rights of the unpaid seller against the buyer. So apart from the rights over the goods, the seller also gets rights against the buyer personally. So what are those rights? Let's understand one after the other. So firstly, suit for price. So if the ownership has passed and the buyer refuses to pay, now the ownership has transferred but the buyer has delayed in the payment. Here the seller can sue for the price. Okay. Then he also has suit for damage, which means if the buyer wrongfully refuses to accept the goods. Okay. And also there is suit for anticipatory breach. That means if the buyer declares he will not perform the contract, the seller can immediately sue the buyer. Okay. And also the seller can claim interest on delayed payment. So, in today's session, we have seen how the Sale of Goods Act creates a balance of power in every contract of sale. We began with caveat emptor, where the buyer is warned to be careful. We then saw how the law steps in to protect the buyer through remedies for breach of contract. And finally, we met a very powerful character in business law, the unpaid seller, who is not helpless when the buyer defaults. But here's the real question. In real life, disputes never comes with labels saying this is caveat emptor or this is right of lien. Now, real cases are very messy, people hide facts, promises are broken, goods are delayed, payments are failed. So, how do you, as future professionals, quickly identify who is at fault, which right or remedy applies, and what will the legal outcome be? So, in the next and final video of week 5, we are not going to revise the theory, but we are going to become judges for some time. So, I will give you real life business situations. So, you will decide the fault, you will choose the legal remedy, and only after that, I will reveal what the law actually says. Okay, so think of it as a business law detective game. Don't miss that session because that's where this chapter stops being theory and starts becoming a skill. See you in the next session.